faithfully conveying value, interpreting great books from around the world. Hello, this is Sally's Book Talk. Today we'll interpret the book Circle Justice for you. From the earlier Zhang Ge case to the recent heated Zhang Kuku case, various cases have been topping hot search lists, sparking widespread public debate. Who's right and who's wrong? Is the judge's verdict just? Why do lawyers defend the wrong side? What exactly is the purpose of the judicial system? To answer these questions and spread legal knowledge, author Luo Xiang wrote Circle Justice. Luo Xiang, author of this book, is a professor at China University of Political Science and Law's Criminal Justice School, specializing in criminal law, philosophy, economic criminal law, and sex crimes. Beyond academic research, he's devoted to legal education and judicial exam prep. Known as the king of legal pop science jokes, his popular book, Fountain Justice, compiles 49 essays blending legal insights with cultural commentary. With candid introspection and sharp analysis, he explores law, morality, justice, and rights while sharing reflections on love and life. This book not only promotes legal awareness but guides readers to examine law and life through a rational lens. I'll discuss this book in 4 parts. Part 1. The relationship between law and morality. Part 2. The relationship between law and justice. Part 3. The relationship between law and rights. Part 4. Reflections on love and life. All right, let's begin with Part 1. Law and morality. What is law? Simply put, it's society's rule system, like civil law regulating personal and property relations between equals. This system originates from people's moral expectations. Law carries morality, but doesn't supersede it. As British jurist Stephen said, legislation must align with the nation's moral standards. Just legal punishments require overwhelming moral consensus, because law can't exceed its people's virtue, though it refines itself as standards evolve. Let's take the case of Granny Zhao in Tianjin as an example to see what happens when law and morality don't fully align. In 2016, 51-year-old Granny Zhao was running a shooting stall on the street to make a living. Later, during a police investigation, she was caught because 6 gun-shaped objects on her stall, powered by compressed gas, could fire normally. She, along with over a dozen other shooting stall owners, was taken away for possessing non-military guns powered by compressed gas. Later, the first instance court sentenced Granny Zhao to 3 years and 6 months in prison for illegal possession of firearms. Although she appealed, the second instance court still found her guilty, but commuted the sentence. Granny Zhao received a 3-year prison sentence with a 3-year probation. Many ordinary people don't understand. Aren't the air guns used for popping balloons just toys? Granny Zhao didn't even know she was holding firearms and caused no actual harm. Wouldn't a warning and education suffice? From the legal community's perspective, the reason Granny Zhao's case caused a huge public outcry is because the judicial authorities have a tendency to rely solely on objective criteria like quantity and joules in handling gun-related cases. Possessing 2 or more non-military guns powered by compressed gas without approval constitutes a crime. Whether a gun-shaped object is considered a firearm depends mainly on whether its muzzle energy density is greater than or equal to 1.8 joules per square centimeter. Clearly, this overlooks an important concept in traditional Chinese legal thought. Ignorance of the law is not a crime. Later, on March 8, 2018, the Supreme People's Court and the Supreme People's Procuratorate jointly issued a judicial interpretation on firearms. For cases involving guns powered by compressed gas with lower muzzle energy, sentencing should be discretionary, considering not only the number of guns, but also factors like their price, intended use, the perpetrator's subjective awareness, overall assessment, and social harm. This firearms interpretation is a change made by the law in response to the public's simple moral demands, and it validates the author's point that the rationality of criminal law comes not from metaphysical reasoning, but from the moral concepts it serves. Law is the carrier of morality, but it also only sets the minimum moral requirements for citizens. Therefore, while the law prescribes consequences for harming others, it is powerless in dealing with failures to rescue. Let's look at another case. A video that went viral on WeChat Moments showed a woman hit by a taxi while crossing a crosswalk. Bystanders did nothing, and she was then run over by a second car, ultimately dying in the accident.
As the video spread, public opinion boiled online, with some saying indifference has become an incurable disease in our society.
Others suggested adding a failure to rescue offense to criminal law, trying to use legal means to prop up crumbling social morality. In the author's view, while law cannot elevate public morality, it should at least take action. In fact, globally, there are two legislative approaches to address failure to rescue: Bad Samaritan laws and Good Samaritan laws. Good Samaritan is a Christian cultural term referring to compassionate helpers who intervene in emergencies.
Thus, Good Samaritan laws, also called volunteer protection laws, aim to remove rescuers' legal worries.
If someone rescues others in good faith without payment, unless acting with intent or gross negligence, like using irrational methods causing death or serious injury, they shouldn't bear liability even if mistakes occur during rescue. This way, doctors seeing collapsed elders can help without hesitation. This legislative style is common in English-speaking countries, while Bad Samaritan laws require citizens to assist those facing serious harm when doing so poses no personal risk or face consequences. For example, during violent crimes, bystanders should at least call police. Inaction could be criminal. Such offenses are misdemeanors, usually handled with restraint. This legislation originated in 19th century Portugal and was adopted by 15 European countries, including Germany, France. So which legislative style is more effective? Socially, Good Samaritan laws clearly outperform Bad Samaritan laws because encouraging goodness is easier than forcing it. Why do so many refuse to help? Perhaps it's not just moral decline. Most people fear repercussions, especially with numerous cases of rescuers being extorted. Rebuilding morality requires multiple systems advancing together. Currently, China's laws can only minimize rescuers' potential burdens.
For instance, in false accusation cases against rescuers, extortion charges punish accusers to protect public kindness.
For some failures to rescue, we can only express our inner anger through moral condemnation. For instance, in the Zhang Jie case, when Zhang Jie faced mortal danger, Lu refused to open the door to save herself, igniting public fury. Netizens mourned the innocent life lost and found Lu's selfishness unforgivable. Lu. Thus, the denunciations on social media became classic moral condemnation. Why do people engage in moral condemnation? First, because we all carry an ideal human archetype within: noble, brave, grateful, and virtuous. When others' actions severely violate this ideal, it sparks our inner rage. Second, it's to inspire reformation. The public's persistence with Liu stems from wanting genuine change, not superficial apologies, like parents' ultimate punishment, indifference that enables a child's downfall. Sincere criticism aims to prevent Liu from being consumed by humanity's darkness. Third, it expresses moral superiority, like those occupying moral high ground, strict with others but lenient with themselves, gaining validation through blame. Beyond that, moral condemnation may seek attention, create buzz, or exploit others' pain. Clearly, the first two motives are well-intentioned, and their resulting anger is natural. But we must stay vigilant, never wield morality as a cudgel or cross legal boundaries. So what's the proper approach to moral condemnation? The author believes morality should radiate inward out. Morality's primary mission is self-discipline, not disciplining others. Thus, moral condemnation must first turn inward. We must first ask, how would we act in similar circumstances? Like in Zhang Gei's case, while Li's cowardice warrants condemnation, how many have honestly asked if they had matched their proclaimed bravery? True courage demands sacrifice. That's what makes it precious. As the saying goes, when you point one finger at others, four point back at yourself. Ultimately, the evil within each human heart fuels all worldly sin. Therefore, moral judgment must always begin with oneself. The anger we feel toward others' disgraceful behavior shouldn't just be emotional expression. It should spark active self-reflection. When criticizing others' cowardice, we should consider whether we could take that step ourselves. When condemning others' ingratitude, we should examine whether we show true gratitude to our loved ones. Well, all right, that concludes the relationship between law and morality. Let's briefly summarize. Law originates from the people's simple moral expectations and sets the minimum moral standard. In elevating morality, law primarily encourages good deeds by protecting the virtuous. Law encourages good deeds mainly by protecting those who do good. When facing morally infuriating situations, we must wield the cudgel of morality cautiously. Part 2. Let's discuss justice, the radiant aspect of morality, and its relationship with law. Here we must mention Justitia, the Roman goddess of justice, often depicted atop courthouses or in town squares across Western nations. Her statue typically features blindfolds symbolizing impartiality. Justice isn't swayed by bias or interference. She wears a white robe symbolizing moral purity and integrity. She holds scales representing fair judgment. Before justice, all receive their due, neither more nor less. Thus, law seems born for justice, with the judiciary as its guardian. But this is ideal. Reality is far more complex. In this book, the author uses circles to illustrate law's relationship with justice, hence the title. In reality, no tool can draw a perfect circle, yet the concept of circle exists objectively. If we see circles as metaphors for justice, every attempt to draw one becomes a pursuit of justice. Here are 3 representative ways of drawing circles. The first type scribbles randomly, drawing, say, a quadrilateral, and calls it a circle. When those in power do this, it may test subordinates' loyalty, like Zhao Gao's pointing at a deer and calling it a horse. If subordinates mimic this, they blindly follow authority. For those who believe the leader's views are the supreme law, interests can override justice. The second type tries hard to draw circles by hand, but they always turn out irregular, so some get discouraged and even give up. Some people console themselves. There was never a perfect circle. Fools trouble themselves. Since all we do is so far from justice, perhaps justice doesn't exist at all. After ideals shatter, the resulting emptiness makes them view everything with cynical sarcasm, slowly turning into the first type. The third type learns to use advanced tools like a compass. When they draw a decent circle, they're thrilled. But slowly, they become obsessed with their own circles. So perfect, they define them as the standard. If someone reminds them there are more perfect circles, they see it as a challenge.
Because they've essentially made themselves representatives of truth.
We compare the truly perfect circle to the ideal state of justice, how it should be. And in reality, all imperfect circles represent the actual state of justice, how it is. When we say law should pursue fairness and justice, this justice is ideal, though unattainable, we strive for it. Realize that ideal justice isn't a human invention, but an objective existence. This helps us escape the 3-circle drawing mindsets and always revere justice. Those in high positions will know. Power has limits. They won't call black white or evil good, nor proclaim themselves truth's representatives. The arrogant think they can build heaven on earth alone. Those in low positions gain courage to resist unjust orders, and even when forced, can raise the gun barrel by 1 centimeter. Now, as for the general public, we respect those in power. Even when criticizing, it's with the best intentions, hoping they act fairly. When we strive wholeheartedly but justice seems distant, we may feel frustrated, yet still hold hope. Because even if justice is invisible and intangible, we firmly believe it's an objective ideal. Ideal justice and actual justice are eternal themes in law. As a legal professional, the author constantly reminds himself that justice like a perfect circle, is the eternal pursuit for all in law. And because once the public loses faith in ideal justice, tragedy is bound to happen. On New Year's Eve 2018, Zhang Kuku killed the three Wang brothers to avenge his mother who was beaten to death decades ago. Reportedly, after Zhang Kuku's mother died, the youngest Wang brother, being a student under 18, was only sentenced to 7 years in prison and paid the Zhang family 1,500 yuan. The Zhang family believed the killer wasn't the youngest Wang brother. He was just pushed out to take the blame because of his age. But when the Zhang family appealed again later, their petition vanished without a trace. Thus, the seed of hatred was planted in the 13-year-old John Kuku's heart, ultimately causing this tragedy. Behind nearly every high-profile case, we see divided public opinion, where vicious acts under the law get cheered online, with descriptions like this emerging. Zhang Kuku joining the army showed loyalty to avenge his mother. Not harming innocents showed benevolence. Turning himself in showed righteousness. What netizens call loyalty, filial piety, benevolence, and righteousness is the chivalrous spirit common in martial arts novels. But returning to reason, there are at least 2 points worth reflecting on behind this chivalrous spirit. First, individual understanding is limited. Many hidden facts remain unknown, so personal views of justice are inevitably partial. Using limited personal understanding to uphold justice risks disastrous consequences. Second, a healthy society isn't black and white. Sometimes good conflicts with good. Therefore, our pursuit of justice must operate under rules, using them to filter out acceptable relative justice. Whether in children's games or adult sports, humans constantly learn to establish and follow rules. But games often descend into chaos, matches into brawls, either due to unfair rules or refusal to comply, highlighting that rule of law is fundamentally rule-conscious. Aristotle argued that rule of law entails 2 meanings. Established laws must feign universal obedience, and the laws people obey should themselves be well-enacted laws. Only rule of law can make people abandon vigilante impulses. Only by placing rights within rules can the public confidently seek solutions within the system. Part 3. Let's discuss the relationship between law and rights. On the surface, the law resembles a knife handle, pointing at all criminal behavior. But actually, law isn't a knife handle, it's a double-edged sword. One edge against crime, the other against state power, because law commands secular society and must restrain all authority, including rulers. Like criminal law, it confronts criminals to protect the state, confronts the state to protect the accused, and confronts prosecutors to protect citizens, becoming a Magna Carta against judicial tyranny. This reflects what German scholar Radbruch called criminal law's paradox, rooted in its dual mission. In 1997, China's criminal law established the principle of legality. No crime without law, no punishment without law, balancing crime punishment with restraint of punitive power. Precisely this transforms law from knife handle to double-edged sword. The author believes even the greatest figures require moral and legal constraints. Unchecked power inevitably unleashes the darkness within humans, bringing catastrophic disaster. Rule of law's essence lies in using public rules to constrain power, giving people predictable expectations, and dispelling fear of the unknown. In this process, lawyers are indispensable, a vital link. In every socially debated case, we hear public condemnation of defense lawyers, people arguing they shouldn't defend criminals. And yet few realize defense lawyers and courts share the same goal: ensuring judicial fairness. Why do people say that?
First, defense prevents wrongful conviction. Ordinary people can't easily distinguish guilt from innocence.
If only the obviously innocent received defense, countless innocents would be wronged. Lawyers' professional training exists to minimize miscarriages of justice. Second, lawyers must defend clients' lawful rights within legal bounds, upholding law's dignity by protecting interests. Ultimately, criminal law balances punishing crime with protecting human rights, seeking equilibrium between these two values. In the Hangzhou nanny arson case, renowned legal scholar Professor He Bing defended the accused Mo, protecting her rights to defense, appeal, and lawful property. Thirdly, forces that proclaim themselves embodiments of justice may also forget justice's original purpose. Power leads to corruption, and absolute power leads to absolute corruption. Lawyers oversee judicial organs to ensure fair trials through due process, thereby upholding the law's dignity. The final part discusses the author's advice as a legal professional on love and life. And so, first, on how to love. The author repeatedly cites Rousseau as a counterexample, because this world-renowned educator and thinker, who wrote Discourse on Inequality, sent his own 5 children to orphanages. The author analyzes that Rousseau's contradiction stemmed from loving humanity while neglecting actual individuals. Humanity is abstract, a perfect concept that's always admirable, but every concrete person is imperfect and flawed. Loving concepts requires only intellectual effort with minimal cost. Yet true love demands sacrifice. The more time and patience invested, the greater the love becomes. Love without cost
Either deceives oneself or deceives others.
Thus, the more one loves abstract humanity, the more they despise actual people. And some only love themselves. While preferring those who like us is natural, this love is largely selfish, essentially narcissism. It merely favors what one already likes and approves what one endorses. Thus, many seeking love through multiple partners end up increasingly lonely. Narcissistic love can't endure. No one meets all preconceived expectations. Everyone loves a lovable person, but when they're no longer appealing, if you still cherish them and seek their hidden beauty, that may be true love. Achieving this requires a tolerant heart. The second theme concerns life. On this topic, let me ask, should euthanasia for the terminally ill be legalized? Proponents argue life only has meaning when quality is maintained. For terminal patients with exhausted treatment options, death is inevitable. So why not minimize the suffering they endure? Euthanasia isn't about transitioning from life to death, but bringing peace during dying. Opponents argue, allowing euthanasia robs patients of 3 recovery chances: natural healing, continued treatment, and future medical breakthroughs. So what's your answer? Now consider this. Do humans have the right to suicide? This question also divides opinion between supporters and opponents. Essentially, both debates center on whether one can dispose of their own life. Responses split into 2 schools: consequential utilitarianism and traditional deontology. Utilitarianism holds that pain or pleasure governs humans, and morality's highest aim is maximizing happiness where pleasure outweighs pain. Law's fundamental purpose is pursuing the greatest happiness for the greatest number. But this stance fatally neglects individual rights and human dignity. Greatest happiness enables majority tyranny and lets minorities violate rights under majority pretense. Thus, utilitarianism stays ambiguous on life disposal rights. Unlike utilitarianism's vagueness, the ontology clearly states, disposing of life is wrong. Suicide equals murder. Legalizing or neutralizing suicide erodes the sanctity of life. Law shouldn't interfere if actions don't harm others. Is purely hypothetical vacuum theory. Human actions always affect others. Society is an organic whole with countless interconnections. Suicide may be personal, but its consequences inevitably impact others. Once life's sanctity is ignored, all evils gain justification. Moral constraints reasonably limit freedom, preventing self-destruction through unchecked liberty. They also restrain state authority, preventing unlimited government power. So the author generally agrees with the deontological position. Humans have no right to dispose of their own lives. Suicide is wrong, but not every wrong is a crime. As the strictest punitive measure, criminal law doesn't target those who attempt suicide. Some say humans face 3 inevitabilities: suffering, death, and evil. This inevitability declares humanity's finitude. In the author's view, every person lives a life oriented toward death. On this life journey, we inevitably experience suffering. We must constantly battle the evil within our hearts until reaching life's end. The key is how to make one's life more meaningful. If the first three parts interpret from a legal professional's perspective, revealing law's meaning and logic, then the final part shares Professor Luo Xiang's personal journey as an elder offering hopes for the young. May we think critically, uphold justice and hope, never abandoning simple moral conscience. Circle justice. Justice. This concludes our interpretation. Reading notes are below the audio. Until next time.